Okay. Hey, kids, I hope you can hear me okay. Uh, yes, I know I'm not usually using my normal uh, whiteboard presentation stuff, so I'm going to try to condense down for you some of the stuff that we've been talking about on the show. For the more for the reason, number one, for your knowledge, number two, because I know there's a lot that goes on with the show and seeing John there and Kirk there and everybody there. And I think this would probably be easier for you. So one of the things we talked about in the show last night was specifically a fraud upon the court and how that works. So now when we talk about things, when you go into court and you're using, words and language and specialty terms, what we refer to in private practice as nomenclature. So that would be a specific reference to a thing, whatever the thing is. If it's called a framus, you call it a framus, not a freemus, right? So a freemus could be a slang term to describe a framus. So kind of help you get to that. But basically, one of the things that we talked about in the show last night when we did our 15 minutes of shame was specifically the event that led to the fraud upon the court in Kirk's case. So I'll go back through and I'm going to read you the definition as I termed it in the show. Now, the actual definition of fraud comes from the Black's Law Dictionary, 10th edition, the preferred text of the court, on page 775, okay? And the first number one definition is a knowing misrepresentation or knowing concealment of a material fact made to induce another to act to his or her own detriment. Fraud is usually a tort, but in some cases, especially when the conduct is willful, it may be a crime, also termed intentional fraud. Okay, so let's go into fraud by itself is a civil crime, okay, or a person versus person. Okay, that makes it civil. What makes it criminal is if the person willingly walked into court and lied. That's where it turns into criminal or intentional fraud. So when we talk about where's the threshold, does it rise to the level of criminality? Okay, what was the level of intent did the person who did it or say it intend to cause harm or whatever? Okay, so because the person who entered that information in his case intended a specific outcome that resulted in damages to him, that's where we would go in and argue that, yes, that crosses the threshold from civil to criminal, making it intentional fraud, okay? Because the act itself, the document itself is fraud. The action in pursuing the document or presenting it as it was presented is intentional fraud or done perpetrating a fraud upon the court with intention to establish an outcome, okay, whatever the desired outcome was. And when we talk about an actual fraud, okay, this is a little bit closer to our situation. A concealment or false representation through an intentional or reckless statement or conduct that injures another who relies on it in acting. So in other words, the concealment of the report from our original case, our original divorce case, which the judge pulled out of the file and concealed it in her private cabinet, okay? That is a concealment or denial of exculpatory evidence, which of course is in all the documents. I'm sure you've read them by now. So because that is a concealment, and by concealing a false representation through intentional or reckless statement or conduct, okay? It wasn't she didn't state that she was doing this, she just did it. She walked into the file room, picked up the report from the case file, took it to her office, and stuck it in her drawer and locked it in her drawer. That is conduct, okay? So yes, that is an intentional fraud, but It's also termed fraud in fact, or positive fraud, or moral fraud. Okay, positive fraud because it required an action, a positive action. Moral in that it was morally questionable for her to do that. So knowing what her desired outcome was, was to steal 8 out of every $10 that I was supposed to be, that I would have normally been paying to you guys for child support. That's basically how they pretty much utilized that our particular situation in our case to steal or thieve that 8 out of every $10. That's where it began. Okay, so I don't know if you guys are seeing this, but on my screen it's weird. Usually this is mirror image. This is usually, I think, well, I'm looking at it on the screen to my left and right, and it's backwards. So if I like a little bit of that, don't be surprised. But anyway, so now we've talked about what fraud is in its base term and how it's manipulated in, from a civil rising to the level of criminality by adding the modifier, right? Intentional fraud means you've established an intention. Okay, so that's how, if you want to take and not necessarily alter the definition of the word, but change its condition from civil to criminal, making it rise from one level to another. That's a perfect example. And here's the reason I'm telling you this, because I'm going to go into the explanation of exactly how the Bar Association is attempting to weaponize the emoluments of government. This is where this goes. So just kind of bear with me as I get through this. So knowing that that's where we're ultimately going to end up, this is the reason that I chose this particular maxim of law when I decided to pursue the emoluments of government as what they are. In other words, their true intention, dating back to the 15th century. So anyway, I added this maxim of law to right next to the definition that is, because it is not never been used, but so rarely ever used in judicial decisions. This one most fit. In order to rightly comprehend a thing, it is necessary first to inquire into the names, for a right knowledge of things depends on their names. Okay, so we're talking about the difference between a framus, which is the proper nomenclature or designation, or a framus, which is its slang term. Both kind of mean the same thing, but if you want to refer to it by its proper name, it's a framus. So in government, those are called emoluments. Okay, a certain political party, which shall remain nameless, but kind of rhymes with democrats, calls those entitlements, right? So that's kind of like, again, where this goes and how we shifted from, its real name and from the 15th century to this proposed new definition in 1991, which also appears on page 638 in the Black's Law Dictionary. And apparently I cannot get through even a live stream without my phone going crazy. So let me shut this damn thing up. Silent. Okay. So let's go back into page 638 of the book of the dictionary, in Black's Law Dictionary, and dating back to the 15th century, the original definition is any advantage, profit, or gain received as a result of one's employment or one's holding of office. Okay, it's been that way since the 15th century. So why in 1991 did they add the word clause after it, right? So this is kind of another reason why I went and put e-clause the way I did it. This is kind of my way of saying busted. So in 1991, they created this entirely new definition, which is pretty ridiculous in that they're saying it comes from constitutional law. The clause of the United States Constitution preventing members of Congress from continuing to serve in Congress after accepting an appointment to another federal office, and also prohibiting such an appointment if the office was created or its emoluments increased while the senator or representative served in Congress. Now, let's stop right there for a minute. Emoluments are what powers we delegated to government makes it limited. Whoever told them they could expand those? Right? So again, this is the right where we're asking for the right knowledge of things, right? So again, knowing that we're going to meet somewhere in the middle here. The question of how do you expand an emolument? You can't expand an emolument, not without the consent of the people. That requires an Article 5 Convention of States under the 3/5 Compromise, where we talked about the prime numbers and how all that came into being. So this is one way to weaken the word emoluments, is to add a modifier to the end of it. So like domestic tranquility, as it appears in the preamble, they add the word violence to it. They take out tranquility and add violence to it, right? You've altered the fundamental description. You've turned the noun domestic, or the modifier, the word domestic, meaning on the land, to in the home, just by changing the word that came after it. Okay, so when we talk about exactly how they accomplish this is why I'm telling you this. So knowing that this definition is fiction, I mean, it came from 1991. How are you going to take something from the 15th century and change it in 1991? Who the hell are you to do that, right? So, and of course, they don't even refer to it as in the proper designation. They refer to it as Article 1, Section 6, Clause 2. Okay, yeah, the word does appear there, but when they talk about the foreign emoluments clause, this is where it gets really ugly. Definition 2, because now they have added a modifier on both sides of the word, foreign and clause. Now we have foreign emoluments clause. So they have literally taken that word and flipped given it a mirror image by doing it that way. Now, how does that what does that mean to weaponizing government? Pay attention to what's going on about this Mueller investigation going on in Washington, D.C., about how they're looking to try to find something, campaign colluded with Russians. Okay, this definition right here on page 638, definition 2 of the emoluments clause, they are looking to create and expand the definition of that, because right now it's just the word foreign emoluments clause. They're attempting to utilize some form of fictional prosecution against the president so they can remove him from office, right? And use that word, change the meaning of that word from the emoluments of government to something they can charge the president with if they basically don't like who he or she is and what he or she says, right? So that's basically because I found it, and being in loss prevention, finding what we affectionately call in loss prevention, finding bullshit, stuff that doesn't belong, and getting rid of it. That's how I ended up with that mandate right there, right? Because I went into the court, showed them exactly what was going on. They're smart enough in logic and reason to know and comprehend that, hey, that's exactly what they're doing, because when they first tried to use my work against the president, even the federal court said they were full of crap. So that's the reason that this investigation is so critical to the Democrats right now. So let's just put that into perspective with current events. So if you're working on a civics assignment or a social studies assignment, you can show your teacher this video and say, guess what? My dad's the only one to ever run this thing through what it means. So maybe one of these days I'll be able to come to your school and teach you guys about this stuff. So that'd be kind of a fun project, wouldn't it? But anyway, you get to say, my dad was the first one that did this. Nah, 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 nah. So anyway, going back to the big book, and one of the reasons I like the big book is because it's the basis. It's the foundations of what we, where this stuff comes from in our ideology and why it's so thick. So, we talk about, the common law and, the Uniform Commercial Code and what's the difference between the two and what applies to who and where and what and when. Again, because I took this fiduciary tool that I got from Congress and said, you have what we refer to in the private sector as an integrity issue, and I'm going to show it to you. So just sit back, relax, and I'll be filing the reports with you guys the same way I did in the private sector when I filed reports with the CEO and the board of directors and all of that other crap. So again, when it comes time to giving these presentations, I've been doing this all of my working career. So not only am I expecting it, I'm actually looking forward to it. So we can kind of get this behind us once and for all and we're done. So, but anyway, I wanted to just kind of give you guys the short version of that without all the show and without all the fluff and, all sometimes the adult language gets a little crazy as we go through some of these shows. So you just kind of bear with us a little bit, we are old and we are having some fun while figure if we're going through hell, we might as well keep going. Right. So anyway, that's I wanted to kind of bring you guys up to speed on the difference between the word emoluments, both appearing on page 638, the word emoluments from the 15th century and how they're trying to change the definition or the intended purpose of the word in 1991. So somebody either on or before 1991 hatched this plan that we're going to weaponize the emoluments of government, and anybody that gets in our way, we'll just manufacture a false prosecution that they colluded with Russia or some other foreign power. And that's how we're going to justify changing that word and its intended purpose to keep out people in government that we don't want there, people we can't control. Okay, so we talk about the deep state and yada, yada, yada. The bar is the deep state. I hate to be the best what. The monopoly itself is the deep state. And again, more further evidence of this is pay attention to what's going on in Washington, D.C. right now with Justice Kavanaugh. He's going through the exact same crap that I just went through after I filed that federal tort in November about where I sat and said, okay, U.S. Congress, I'm going to give you a follow-up on this weaponized family court and where the money flows and how and why they're using it. So when you look at the cover page, that's why I use Title 18, subsection 643. Okay? And I walked in, said, Congress, you guys sit there. I'm going to represent you and give you this presentation right through the form of this tort. And I'm calling Ohio Congress and Florida Congress into the meeting as well. Now, we saw what happened, how the judges first responded to the mere concept of somebody using the emoluments of the court for something other than what they like to play with it, right? They pretty much kind of gave me a stave and kissed my butt. And guess what? Both houses of Congress and any other house of Congress that reviewed that case said, wait a minute, you're going to basically tell this guy he's full of shit, get out of here, treat him with arrogance and disrespect because he called a meeting? Wait, what? So again, knowing that there are good actors still left in government, when West Virginia decided to impeach their entire state Supreme Court, they went in under Title 18, subsection 640. And guess what was plastered all over the media? $30,000 for a couch. One of the justices spent $40,000 on a desk for his personal office, and so on and so forth. But it was also, if you read in the reporting in the language of the local news media reporting, they made multiple mentions of arrogant behavior on behalf of the justices. Where else where would they have gotten the concept of that had they not witnessed it when I called that meeting? So again, I don't believe in coincidences. And taking that to how this connects to Justice Kavanaugh's problem is shortly after I filed that complaint, more allegations of abuse, basically me against you or your mom or somebody, who the hell knows, magically appeared in the state of Ohio. Now, wait a minute. Hang on a second. I haven't even been to the state of Ohio in, 2012 was the last time I actually was there. And so how did they take and make these allegations against me sometime at the end of 2017 when I hadn't left the borders of the state of Florida except to go to Atlanta, Georgia, which I was able to prove because guess what? The stamp of October 10th, 2017 from the U.S. District Court of Appeals in Atlanta is right here. So that's the closest I've been north since 2012. And I can prove that. So again, looking at this the way that they look at this, they're like using logic and reason. They're saying, you know what? Okay, we kind of get what's going on here now. We need to give this guy a mandate or basically grant him standing. That's what this does. This grants your dad standing in court. Okay? And right now we are limiting that standing to issues surrounding what I referred to as the unauthorized practice of law, basically using the emoluments of the court to break the law, which again I proved. So if they admit that, if the justices actually admit that, then they have to admit the court is in disrepute. They can never admit that. There's a reason they cannot admit that. What they can do is they can say, okay, I can give you standing to practice, but because you're following due process of law, right? Not due process of the court. You're following due process of law, and you are redressing your legislature, right? Which is what I've been trying to teach everybody. That's part of the process. If you're only going to court, you're only doing a half of a job. You're not doing the whole job. So again, that's why as you read through this mandate, the word statute does not appear. And because I'm not a statutory actor, I'm a fiduciary actor. There's a difference. That's where my standing, right? What level I stand on in this process changes. When we're talking about the two forms of nobility, the higher and the lower. The lower is the statutory actor. The higher is the fiduciary actor, right? The court recognized me as the higher. That's a big responsibility. And it's not one that I take lightly, and it's not one that I'm going to squander. I promise you. Never going to happen. So, again, as we read through this, we say, you are hereby commanded. That means they're telling me that further proceedings as may be required be had in said cause in accordance with the ruling of this court, this ruling here, and with the rules of procedure and laws of the state of Florida. Okay, follow the process, follow the rules of procedure, which I've clearly done, and paid due respect, and the laws of the state of Florida. That's the limitations of my emolument, and I'm perfectly fine with that. So, again, there's no harm in that. That's basically saying, dude, you're following the law. Keep going. So, okay. And it was witnessed by the Honorable J.P. Cohen, Chief Judge of the District Court of Appeals from the state of Florida, 5th District, and the seal of said state court at Daytona Beach, Florida on this day, September 18, 2018. Happy birthday, Stephen. So, here's the seal. That's why I said, here's the seal. I don't know if you can see that or not. My fat finger in the way there. That's what the seal looks like of the state court. And that's why I said there's a lot of weight in this piece of paper. And I mean a lot of weight. So that's got to be handled correctly and handled with care. So that's one of the reasons I'm spending so much time, especially lately, doing so much research. And I just posted another document in the group today with this document attached to it. So if you guys want to get a hold of that and kind of thumb your way through it a little bit, that'll kind of give you the idea of what that is, how it works, et cetera, et cetera, et cetera. So on that note, without all the fluff from the show, I just wanted to come on here and kind of give you guys just kind of the condensed short version, if you will. And I thought there was one other thing I wanted to touch base with you guys on before I go, but I'm not seeing it here. That's the order. That's the mandate. And rules of the court. No, I think I pretty much got everything. If so, I'll just do another video. Yeah, sorry, I don't have any kind of fancy schmancy stuff to put on the board for you this time. So other than my usual, I'll just let you guys know that I love you. And I hope to see you soon. So have a good night. Love you guys.